Hello again, hope you're all doing well. This is a free preview on defending fee petitions in family law because sometimes the other side or maybe former counsel wants their 10 pounds of flesh. Tell me you're familiar with Shakespeare's Merchant of Venice, but if you're not, don't worry about it. This is a reshoot of a reshoot of a reshoot. The original version was supposed to be 2 hours long, but after looking at it, oh man. Honestly, if you need cheap CLEs, I just saw one that offered 30 hours for 80 bucks. Heck, the ISBA gives you 15 hours cheap as free each year. So for quality reasons, I just reshot this whole thing again, cut out all the fat, kept all the case law. It's designed for all levels of practice. However, I've tried to make this as accessible as I can both to like boot lawyers fresh out of law school and old hats. Finally, the CLE is pending CLE credit approval. So we might not get jack squat from this. I don't know how the MCLE board treats these, but the proceeds go to CVLS regardless, the best legal aid charity in the universe. And let's be honest, as lawyers, we have friends in hell, so we need all the karma points we can get. Just buy it, man. It's gonna go to a great cause. The link to purchase is down below. Email me if you have any questions or comments about it. And let's just get to the free preview. Appeals involving an attorney fee award are always challenging, but for reasons you might not expect. Case in point, a few years ago, this mom and pop law firm calls me up. They were on the losing end of a fee petition that came about from discovery sanction. It was an uncomplicated child support dispute involving two W-2 parents, meaning this wasn't rocket science. The firm repped mom, but she was like super late in complying with discovery. The case dragged a couple years, but some of that was due to the COVID shutdown, but unfortunately a lot of it did come from the non-compliance with discovery. Now, I don't know if it was the firm that made the case a low priority, if mom was just this really hard-headed person. My guess is that it was probably a little bit of both. But the other side was repped by this well-known big box law firm in the Chicagoland area, and after hearing, the judge awards them 18,000 bucks. Now that mom and pop firm was like hot over the sanction. So the first 15 minutes, I'm just kind of like, okay, letting them kind of vent a little bit. But from what I could glean, their sole defense at hearing was that the stakes were kind of too low to justify a fee that high. Now, normally abnormal fee awards are good candidates for an appeal, but, and there's always a but, the firm did not specifically attack the problematic time entries. They just sort of argued generally that it was unreasonable in light of the amount in dispute. But in Illinois, that's not really a good defense when sanctions are involved, because such a policy would encourage non-compliance with court orders. Easy example here, if dad was supposed to pay 200 bucks a month in child support, but knows if he skips a payment, mom would have to go pay a lawyer 2,000 to get a contempt action filed. You can see where that's going, right? And that's per the Foglanio case. And forgive me for butchering certain names. I'm just terrible with pronunciations. Additionally, though, even if this weren't a sanction situation, we have a Thomas decision from years ago that holds the same thing, that lawyers suing former clients when the amount in dispute is less than the legal bill, that's okay. And these cases have been on the books for decades. So turning back to that call, right? Once I had a couple seconds to tell them that a good appeal can't fix a bad trial. The formal term for this is called forfeiture, which applies to challenges on attorney fees when you go up on appeal. So after I told them that slogan, the phone got real quiet. Then I heard a click. So it happens, right? And for those wondering, a motion to reconsider probably wouldn't have helped them any unless there's an incredibly great reason involved. You just can't raise new arguments for the first time in a motion to reconsider. That's straight from the Lysag decision. Lysagi, go with it, right? And I know some of you might say, hey, the judge is the one that determines reasonableness. They should have put the brakes on an $18,000 fee award. Yes and no, and maybe so. I don't know, because the general rule actually is that the courts are not expected to search through the record in order to develop argument for you. So in English, if you just decide to mess the hearing up, you mess your defense up, a good appeal isn't going to fix a bad trial. I'm going to be repeating variations of this throughout the CLE, just bear with me. Now, to be fair, appealing an attorney fee award is not some hopeless endeavor. If you look at the case law, courts reverse fee awards all the time for all sorts of reasons. Sometimes it's because the fee sought went beyond the scope of the petition, or the lawyer filed the wrong fee petition, or the judge arbitrarily changed a lawyer's hourly rate, or the lawyer sought disallowed costs or fees or other irregularities. And those cases are featured in today's CLE. But you have to treat that hearing like the Super Bowl. So to help you out, on the last couple pages of the CLE handout is a checklist I made. It tries to be a one-size-fits-all, but obviously each case is going to be a little different. But look at that as a starting point in defending your client against unreasonable attorney fees. And we'll be using it for today's CLE. So let's get to it. Part 1. There is going to be a temptation to want to hit the fast forward button. Please don't. If you hyper-focus on the technicals, you're going to miss the obvious. And what the obvious is, well, what is reasonable will vary. Just kind of like a hamburger at McDonald's is going to be, well, hopefully a little bit cheaper than Gordon Ramsay serves at that burger place in Chicago. Lawyers were kind of the same deal, but with certain limits. Lawyers can't charge whatever they feel like. Gordon Ramsay can, we can't, because as Patilla states, attorney fees are regulated to protect the public. And when it's a fee-shifting situation, there's actually stricter scrutiny by the trial court because that attorney that's seeking the fees has no fiduciary relationship with the party that is going to be liable for the payment of those fees. Now, whether it's a former client or a fee-shifting situation, for family law cases, we generally use the Patel factors, which are somewhat similar to Rule 1.5, but not entirely. To kind of give you an idea what I mean, when you line up Rule 1.5 with Patel, it's close to identical. I have this chart that I put in the guide that shows you what's the same and what doesn't have a corresponding factor. But going back to the burger comparison, in theory, the quality at burger and the price, well, higher the quality, higher the price, right? We shouldn't complain about a $20 idiot burger. That's actually a real thing there. Because when you look at where you're at, kind of makes sense. But if Gordon Ramsay wanted to charge, let's say, $2,000 for that same burger, I think most people might scrutinize what goes into it before placing their order. Same principle with attorney's fees. So when you're facing an attorney fee petition, you gotta frame your case realistically. For example, how many hours did that firm claim they incurred in order to handle, let's say, a contempt matter? If it was 4 or 5, that's probably just off the top of my head going to be in the ballpark of what's reasonable. But what if it was 40 hours for a cut and dry missed child support payment? It's kind of a tall ask there, right? Or as we'll cover later, what if the firm charged 15-minute billing blocks or a minimum 1-hour court appearance for, let's say, a 5-minute Zoom status call? Another Patel factor, the skill and standing of the attorneys. How many times is this factor ignored? Because we all know that firm, they got 2 experienced partners who haven't stepped foot in a courtroom in decades, and they outsource like 95% of their associates that they have. They're boot lawyers straight out of law school. They send the associate there to do it, but the firm is still billing like a $700 an hour rate anyways. Or the difficulty of the issues. That firm billed 5 hours to research contempt when the issue was just one missed child support payment. But let's say on the other side of that, let's say the issue turned on some obscure issue in the bankruptcy code, because family law and bankruptcy, well, they unfortunately tend to go hand in hand. Or the amount and importance of the subject matter. Child custody, sorry folks, that's high stakes litigation. Missed child support payment, it's a big deal, but probably not as big. And related to that, the degree of responsibility involved in managing the case. Cases involving self-owned businesses often have just a pile of financial records, and those always burn hours. So we have to be a little realistic when we get to those cases. Or the usual and customary charge in the community. Oftentimes lawyers in a particular county bill within a certain range. It's just how it is. But what happens when someone tries to exceed that range? We actually have some case law we're going to talk about later today about what that should entail and what you should do when that situation arises. The benefits to the client. This one seems pretty self-explanatory. However, we got a weird case here in a little bit. It involves a firm trying to tack on a resort fee, presumably under this factor. And in case you're wondering, of all these particular factors, the ones that courts are encouraged to look at the most is the amount of time necessarily spent on the case. And that's from the Malik decision, with the caveat, though, that the time charged was necessary to handle the matter involved per the Christian case. Again, the factors matter because honestly, the first step you got to be doing is to figure out what kind of case do you have. For family law, I got a chart here. It's silly, I know, but maybe not. The drama complexity chart. If you're getting fees in this area or even in this area, you're going to have a tough fight on your hands. But if you get them here, you might have something to argue at hearing. Let's just put this really silly chart to use with a recent decision, Anderson from 2021. In Anderson, it looks like mom and dad worked out what they wanted to do. They had a nearly 100% across the board agreement, no kids, but each had kind of the sinking feeling their lawyers were trying to take them for a ride. So they fired both of their lawyers, told the judge their concerns, and then on their own, they proved the divorce up. The wife's former lawyer files a suit under 508C. If you're new to family law, sorry, that's a statute where the lawyer's suing their former client. Anyways, they file a 508C pleading where the lawyer claimed they had an $3,000 owed balance. But the judge, though, after looking at everything, the judge awarded a donut in large part because the lawyer billed mostly for non-court things like emails, phone calls. They made one court appearance, but just to get out of the case, I jumped there, sorry. And perhaps most striking, the delay in being retained and filing an appearance in that matter was like 4 months. So low drama, low complexity. Judge says, here's your donut. And the appellate court was like, yeah, we're good with giving the lawyer the zip. So again, most important thing after you get served with that fee petition, figure out what kind of case did you have. Now, I know we all love shortcuts, so here's one. Outsource this chart to another lawyer who could testify as to what should have been the customary charges. Yes, nothing says salt on the wound better than paying a lawyer to testify why your client shouldn't pay a different lawyer. The jokes just get worse from here, folks. But the lawyer can testify as to what should have been the customary charges because they can't testify as to what's reasonable. Only a judge makes that finding. So make sure we don't conflate this. It's kind of like how you say the defendant's prints were on the candlestick, but you can't say the defendant is guilty. Only the jury or the judge, in this case, makes that call. And there is a drawback with an expert, aside from costs. In most instances, a judge can use their own personal experience in setting that number. It's one of the very few instances where a judge can rely on outside knowledge in reaching its decision, with a minor exception we're going to cover way at the end of this CLE. But just to complicate things a bit more, and there's always a but, right? At the same time, when we look at the Lena S. decision, it's a juvenile decision, but it holds that a judge cannot dismiss an expert's testimony out of hand either. So if you have a judge who isn't too kind on your client, it may make sense to get an expert involved if the stakes are high enough. All right, that concludes the free preview. I'm so sorry it took forever just to get this one out the door. Pre-production hell, what are you gonna do, right? I'm glad to be free of it. Anyways, proceeds go to CLVS. We'll be running this from December 22nd until February 1st. We hope to sell 25 units, which would be a gross of $1,000, almost real money. Of course, we have to minus the vendor and the CLE costs, which I can't do anything about that. It's just set by statute or by their rules. But it's a great charity, and I hope you'll consider it. Now, the rest of the CLE has all the cool stuff. The scam charges, the tricks, the tips, obscure case law, all the cool stuff to either reduce or deny that lawyer from taking every penny your client has, or perhaps every penny they don't. Anyways, that's all I have. I return in January with regularly scheduled programming. Link to the full course should be below. Any issues, give me an email. As always, thanks for watching.